Hello, everyone. Thank you for joining our second community webinar of the summer. Excited to have you all here. We're going to have a conversation with Debi Ghate and Josh McDaniel. Before we kick off that, I will just share a little bit about the Voices for Liberty initiative. My name is Lori Sarah Oliver. I'm the coordinator for the initiative, and we're based out of the Antonin Scalia Law School at George Mason University. So the Voices for Liberty exists, and we support research and scholarship on how free speech and civil rights have interacted in America, how they've supported each other as those rights have developed, particularly focused on how free speech has helped secure civil rights for historically disadvantaged or marginalized groups whose rights have not always been guaranteed. So we sponsor research papers like the one you'll hear about today and like the one we shared in our last community webinar. We sponsor a book in development, and a major part of our program is hosting events on college campuses. So we have a broad speakers bureau, people who are academics, lawyers, really focused on the free speech issues. They travel to college campuses around the country, and they engage with students on topics like this one. So I'll drop a link to that in the chat, and then we will pop Debi and Josh here on the screen. Josh McDaniel is our featured author today. So we'll be discussing his paper on how religious minorities have helped secure secular rights. He's the assistant clinical professor of law at Harvard Law School. We'll drop his bio in the chat and the link to the paper as well, so you all have access to that. And then Debi Ghate is our initiative director at Voices for Liberty. So excited to have you both. We'll drop a bio for Debi in the chat as well, and I'll kick it to you two to start the discussion.
Great. Well, thank you, Lori Sarah, for that wonderful introduction. The Voices for Liberty program has been such a great one to work on. We've really had an opportunity to see what happens if you introduce free speech through the lens of civil rights, and really encourage people to think about whether that kind of progress can be made if you don't have the ability to speak freely. So, Josh, welcome to our community webinar, and thank you for joining us today. It's good to have you here.
Thanks for having me.
All right. Well, Josh, so you wrote a paper that we sponsored, and it was our pleasure to sponsor that paper with you. And it's going to be published soon in the Washington and Lee Law Review, which is wonderful news. But tell us a little bit about what the central argument is of your paper. And I should tell people the title. It's Religious Minorities and Secular Rights is the title of the paper. So what is the central argument that you're making? And, for people who haven't read the paper, spoiler alert, there's a focus on Jehovah's Witnesses in the paper. And so what made you focus on that group?
Yeah, well, thank you, Debi. And also, I would say thank you to the Voices for Liberty initiative for hosting me. It's been really great and wonderful working with you all. So as Debi mentioned, as the title suggests, my article looks at the phenomenon of religiously motivated actors going to court to protect their religious exercise, but not under the First Amendment's free exercise clause, which is what people would think would be the primary go-to, and it often is. But when they go to court and they vindicate their religious rights, but under secular constitutional guarantees. So think freedom of speech is one of the primary secular guarantees that I'm looking at, but it could be anything ranging from equal protection to right to travel to Fourth Amendment protections. You can see religiously motivated actors wanting to protect their religious exercise, but under the umbrella of these secular constitutional guarantees. And so I'm looking at that phenomenon. Many scholars have noted, in particular with respect to Jehovah's Witnesses, if you open any freedom of speech casebook in law school, you'll see that a number of the key cases in those casebooks are going to be cases involving Jehovah's Witnesses. So many scholars have noted that there is this contribution of religious actors to free speech law. But to date, there's been not a lot of scholarship examining this as a broader phenomenon of religious individuals asserting secular rights. And to me, I think this raises a number of very interesting questions. Why did religious minorities assert secular rights historically? Why do they today? How have their secular rights victories affected individuals in other non-religious contexts or even broader secular social movements.
Okay. Thank you. That's an interesting relationship. And when you have options under the law, there's a reason why people are choosing, the religious groups are choosing this path. So I look forward to hearing more about this. But what inspired you to write this paper in the first place? It sounds like it's research that you're really deeply connected with.
Yeah, so in part, it is actually informed by the work that I do with the Religious Freedom Clinic at Harvard Law School. Um, we, in the clinic, represent religious freedom clients on a pro bono basis. We represent people of all faiths. And one thing that we just see even in our own cases is routinely we are asserting claims that are not free exercise claims, but we might have a Rastafarian prisoner client who is asserting Eighth Amendment claims because he's a prisoner, or we might have Amish clients asserting a right to travel claim, or might be representing a street preacher bringing a First Amendment, a free speech claim under the First Amendment. So that's something that we routinely see. But what really turned me onto this initially was a couple of years ago, I was invited actually by the Jehovah's Witnesses themselves, by their organization, to do a webinar with them. And they wanted to do a webinar celebrating the 20th anniversary of the most recent Supreme Court victory that the Jehovah's Witnesses obtained. And for them, their Supreme Court legacy is a very important thing. There's nearly 50 Supreme Court cases involving Jehovah's Witnesses in the 20th century. And so the most recent one was in 2002. It was a case called Watchtower Bible and Tract Society versus Village of Stratton. And the issue in that case essentially involved Jehovah's Witnesses wanting to go door to door in a neighborhood and being arrested because they didn't first go to the city hall to get a permit from the mayor. And one of the really interesting things about that case was that the Supreme Court had before it both a claim under the First Amendment's free exercise of religion clause, but also a claim under the free speech clause. And the Jehovah's Witness plaintiffs in that case were asserting both rights. But the Supreme Court very deliberately did not decide the case based on the free exercise clause, but instead decided the case under the free speech clause. And Justice Scalia made a remark in his concurring opinion that in his view, this was very significant because what it meant was that the court's ruling, ultimately vindicating the rights of the Jehovah's Witnesses in that case, would not be limited either to Jehovah's Witnesses or to religious proselytizers more generally, but would actually benefit everyone. So anyone that wants to go to door for any purpose, whether it's political canvassing or even one of the examples at the oral argument in that case was Girl Scouts going door to door trying to sell Girl Scout cookies. They're not going to get arrested for failing to get a permit first and get approval from the town or the city or the village that they're in. So that really kind of inspired me to start looking into this and started drawing out some of these trends and these patterns where you can actually see a linkage between these cases brought by Jehovah's Witnesses and other religious minorities, and then influencing other movements, including even one of the particular focuses I have is on how the Jehovah's Witnesses cases from the 1930s and 40s really laid the legal groundwork for the Black civil rights movement of the 1950s and 60s. And in some ways, that movement would not have been able to succeed legally and to flourish in the way that it did without those legal protections that were first hard fought by the Jehovah's Witnesses.
Okay, let's dig into that a little bit deeper. Can you share with me maybe your favorite example of where civil rights movements have been able to rely on free speech precedents that were garnered through, the protection of rights for religious minorities? Do you have like a favorite example of how another civil rights movement did that?
Yeah, so it was really interesting digging into these civil rights movement cases and just seeing the parallels between those cases and the Jehovah's Witness cases. So one example that I think is really interesting is one of the most famous Jehovah's Witness cases was a case called Cantwell versus Connecticut. and it's very famous because it's actually the case that in court that clarified that the 14th Amendment made the free exercise of religion clause of the First Amendment applicable to state and local governments. So what in the legal world we call incorporation of that clause of the 14th of the First Amendment, it made it so that not just the federal government, but state and local governments can also be liable for infringing on that right. But in that case, what the case was about was it was Jehovah's Witnesses on the streets playing a phonograph on the street. So this is kind of very old-timey, but playing a phonograph with their religious message. And it kind of a, they had some pretty explicit anti-Catholic teachings because they're advocating for their religious views and arguing against Catholic religious views. And they were in a heavily Catholic area, and their message was considered very inflammatory. Some of the bystanders really did not like what the Jehovah's Witnesses were sharing, and so they were arrested for breaching the peace. And the case went to the Supreme Court, and ultimately the Supreme Court said, no, we've got to put limits on state and local government's ability to use these breach of the peace ordinances in an arbitrary way that stifles free speech, essentially. And fast forwarding then a couple of decades to the Black Civil Rights Movement, you see the exact same tactics that are being used by villages and cities against the Black activists. So one case is the case of Reverend Elton Cox.
Mm.
There was a group of 2,000 college students that protested segregation and discrimination against Blacks, um, and some prior arrests that had been done. And so the group assembled peaceably at the state capitol building and marched to the courthouse, where they sang, prayed, and listened to a speech at the courthouse. And at that speech, Reverend Cox gave a speech. He called for sit-ins at lunch counters, and he was arrested for breaching the peace. Just like the Cantwells, the Jehovah's Witnesses in that case, were arrested for breaching the peace. And just like with the Jehovah's Witnesses, where it was claimed that their speech was inflammatory, a lot of the white onlookers were arguing that this was very inflammatory, calling for the sit-ins at the lunch counters. And so the police had to arrest him to basically prevent a riot or something along those lines.
Mm.
And again, looking at this case, the Supreme Court specifically invoked Cantwell and quoted it at length, and really relied on Cantwell as the linchpin for its decision, saying that it was wrong to arrest Reverend Cox in that situation, and to hold that he obviously does not lose that even if speech is inflammatory, it obviously does not lose its protected character under the Constitution as free speech and assembly. So the court overturned his conviction.
Wow, okay, that is a very clear example of how the case involving the Jehovah's Witness ends up being applied to help protect the rights of another minority group. And it's interesting to me because it's not just minority groups, it's almost like unpopular
Mm.
in terms of time and place and who's involved. It's like it's unpopular minority groups that are getting the protections here.
Yeah, that's
Yeah.
absolutely right. And I mean, that was just one case. You actually see this over and over again. Literally every single Supreme Court case that I found involving the Black Civil Rights Movement um, was just kind of littered throughout with Jehovah's Witnesses cases throughout the court's decision. And in many of these cases, the court is specifically saying kind of these cases are the linchpin to
Huh.
decide this. Another really good one was there out in Birmingham, Alabama. There were protests and marches, and kind of similar to the Cox case. And you had three pastors led 52 men out of a church to march in protest of Birmingham's civil rights violations. And a crowd of spectators began to follow them. And when they had gone 4 blocks, the police stopped and arrested them for violating an ordinance that prohibited parades or processions without first obtaining a permit. So you can almost see like the echo, like you
Yeah.
see echoes backwards to the early Jehovah's Witness cases where they challenged these discriminatory applications of permit requirements. But fast forwarding, you also like think again about that Village of Stratton case from even 2002, where it involved kind of a similar permit requirement, and you see that these things kind of keep cycling back around. And yet again, the Supreme Court, the plaintiff in that case was Reverend Shuttlesworth, one of the ministers who had led that march and who had worked with Martin Luther King Jr. to organize the campaign in Birmingham. And again, the court overturned the conviction, saying that the invoking the Jehovah's Witness cases, saying that the application of the that permit requirement violated his free speech rights.
And boy, did Reverend Shuttlesworth use his free speech rights. He has amazing speeches that he was able to give. All right. So clearly, the Jehovah's Witnesses as a group did something legally that has benefited a lot of other movements, a lot of other groups. It sounds like there was something in their litigation strategy. I'm curious now if we get a little technical here. So, what was it about their litigation strategies that made it possible for them to be the ones to set these kinds of precedents that others have then benefited from?
Yeah, that's a really good question, and there has to be something because they weren't the only persecuted religious minority.
Right.
You could think like Mormons at the time or something like that, but they were far and away the most successful at bringing this legal campaign and actually winning court cases. I think a lot of it can be chalked up to actually kind of the brilliance of their legal advisors. That one in particular, Covington, was one of their Jehovah's Witnesses lawyers who argued a number of their cases in the Supreme Court, and they very much had a top-down strategy where they were thinking about what were the right test cases to bring and which would be the best cases to go to the Supreme Court, what would be the best strategy when they got there. And so they were actually very deliberate about focusing on bringing these secular rights claims as opposed to free exercise claims. And there's a lot of interesting reasons why that might have been the strategy that they chose. But they also had kind of a grassroots level strategy as well, where they had kind of more local level lawyers throughout the United States that were they distributed their phone numbers and had means for any Jehovah's Witness proselytizer who was facing legal troubles to be able to call in essentially to a hotline and to be trained on here's what you do, here's what you say, here's who you contact, and then to kind of have this almost coordinating committee to make sure that there's a good legal defense. And in a way, you actually see a lot of maybe some inspiration or at least a precursor of something like the NAACP, where there was a lot of coordination in the Black civil rights movement context as well.
I was going to ask, so it sounds like they almost developed a playbook for how to do this. And I don't know if your research took you into not just the precedents being used by other groups, but was the playbook also used by other groups?
Yeah,
Going to be a future paper.
yeah, I haven't really found kind of any explicit thing, but you
Yeah.
see kind of an unmistakable parallel between the two in terms of the coordination and following that playbook. I think playbook is a very good way to describe it.
Oh, okay, that's pretty neat. I had no idea. So I don't know, maybe there'll be a future paper from you that talks about that side of it.
Right.
Um, so I'm wondering about this sort of feedback loop between the religious rights jurisprudence and then the modern secular rights development, right? And how has that feedback loop been evolving over time? And what do you think is going to happen in the next decade or so? Because we now have all these issues around technology and AI and other things that people are thinking about. The world has changed since this original jurisprudence, but I'm wondering, like, if this feedback loops continues, where is it going?
Yeah, so I think you will continue to see two things. So you will continue to see these religiously motivated cases that are securing secular rights continuing in the future to influence legal outcomes in cases that have absolutely nothing to do with religion. And then the the second thing that you will see is you will see new religious plaintiff victories being won that are laying groundwork for secular rights, but people not picking up on that and people not realizing that. So, and I can give an example of each. So an example of the first point that I made about these decades old Jehovah's Witness cases, for example, continuing to impact cases today is there was a recent case in the Supreme Court. There's a lot of these debates going on about social media deplatforming, algorithmic bias, AI-driven speech moderation. And you have this question of states coming in to regulate social media platforms because the states think that there's bias in terms of the speech that's being allowed there. And interestingly, when you look at so there was a case that recently went to the Supreme Court called Moody versus NetChoice, and the if you look at the amicus briefs that were filed and also the Supreme Court's decision itself, in both contexts, you see a number of these Jehovah's Witness cases again being raised. Some of them in the compelled speech context, where a number of these Jehovah's Witnesses cases, going all the way back to flag salute cases from a case called Barnett, where the Supreme Court first recognized this idea that the government cannot compel speech by private citizens that they disagree with, whether it's religious or otherwise. And the Supreme Court's then taking that principle and applying it to not Jehovah's Witness children in a classroom, but to YouTube and to other social media platforms, and saying that this same principle applies in that extremely different context. Um, and then in terms of the new religious plaintiff cases that we're seeing here, I see all the time cases that are brought by religious plaintiffs where they're asserting secular rights, but it totally gets lost in a lot of the discussion about these cases. So one example would be the pretty famous example of the football coach at the high school in a case called Kennedy versus Bremerton School District, where he was praying at the 50-yard line. And this was a kind
Yeah.
of controversial case in terms of balancing the interests of the students and the religious freedom rights of the coach. But lost in the discussion of all that, I think, is the fact that the court not only ruled in his favor on free exercise grounds, but also said there was a free speech protection in this case, and that he had proven his case under the free speech clause, which I think then raises very interesting questions about what will be the ripple effects of that free speech ruling for other public school teachers in totally secular contexts where religion has nothing to do with it. And I don't really see a lot of discussion about that, but I think that's something that we will see in the future, is we will see those kinds of effects. Another case, again, involving a somewhat controversial plaintiff is the 303 Creative versus Alenis case involving the website designer who had a conscientious objection to designing websites for same-sex marriages. And again, a lot of the focus on that was on are we giving this special opt-out right for a religious plaintiff in this case under the free exercise clause? But the interesting thing about that case was that the Supreme Court actually didn't even grant certiorari on the free exercise clause claim that had existed in that case, but instead took up the case only on the free speech clause and ruled only on that ground. And
Okay.
again, actually, you see that case in the social media case, the Moody versus NetChoice case, being cited in amicus briefs and by the court in that case as a precedent that's informing how should states regulate social media companies.
Wow. Okay. So you actually anticipated and answered one of my questions, which was this is a pattern of you try to assert both claims, free exercise and free speech or some other secular right, and the court will go with the secular right in some cases.
Yeah,
That
you
makes
see that sometimes, although, I think one of the really interesting things is historically, oftentimes Jehovah's Witnesses would have brought both claims. They would have brought
yeah.
both the free exercise claim and the
Uh-huh.
free speech claim. And the court would kind of go out of its way to do the free speech, freedom of
Right.
assembly, freedom of petition type claims, and not the free exercise claim, And at the time, that might have been just because the free exercise clause was not really developed at that point. There was not really a clear standard. A lot of the key precedents about how do we interpret the free exercise clause don't really arise until the 1960s, which is decades after these Jehovah's Witness cases. And then what we see kind of in recent decades now is that there's been kind of this resurgence of, although you have both options, the court is tending towards the free exercise claim to decide cases. But we do have a few very recent cases like that 303 creative case where you see the court going kind of the other direction for whatever reason.
Yeah.
And it's interesting to speculate about why that might be.
Yeah, that is fascinating. In other words, there is a relationship here that you that you are studying and that there's more to study here. But we do have a couple of questions from the audience that I want to quickly ask you before we wrap up. Um, excuse me. One of these questions is, do you think these same strategies would have worked for other religions, or is the witness's success a product of their specific religious ideology, for example, nonviolent and it being apolitical? So is there something about their religion that was involved here?
Yeah, so one aspect of their religion that really fed into this was the fact. So, and I actually did not know this until I worked with the Jehovah's Witnesses on the webinar in a couple of years ago. But they actually have a religious belief against engaging in politics in any kind of form. So they don't register for political parties, and they believe that they can't, like, it's against their faith to even go lobby to Congress or to Congress people. And so the way they look at it, and I was kind of able to hear from them personally, is the way they look at the courts is it's really their only uh, it's their only means of securing legal protection because they as kind of a matter of faith they don't go to Congress to lobby and they don't vote in elections, and so that's not really a way for them to protect themselves. And so the only way for them to protect themselves is to go to the courts and to seek the legal protections in that way. And I'm not really aware of any other faith that kind of has quite that distinctive and strong of a belief that really kind of the courts is the only refuge for religious reasons. Um, and then I think also I think this is true to varying degrees with other religious groups, but they were just kind of so set on their need to proselytize that they, even if there were consequences, even if it involved being arrested, they would do it. They would go to these kind of legally precarious situations and they would pursue their exercise of religion. And I think that's a very meaningful reason why you see so many of these cases coming out from the Jehovah's Witnesses was because they truly felt compelled by their religious beliefs to basically incur these legal consequences.
I got it. So there was much more than litigation strategy in this case, that
Right?
makes sense. I cannot believe the half hour went by that quickly. Lori, Sarah, I see that we're at 12:30, so I'm going to kick it back over to you.
Okay. Oh, sorry. Well, thank you, everybody. Sorry we couldn't get to all the questions, but we'll hopefully hold another event soon. Thank you, Josh and Debbie, for joining us. Really appreciate it. Did drop a link to Josh's paper in the chat, so if anybody wants to dive in further, they can look there and also look out in the Washington and Lee Law Review for the upcoming publication. You can also find there some of the other papers. Some of you might have been on for our webinar with Claudia Kramer. Her paper explores correlation in data between free speech protections and racial tolerance in different countries. It's a fascinating piece. We also have some papers on other key Supreme Court cases, historical developments in free speech, lots to see there. And then I also just dropped a link to our speakers bureau. So if anybody on is a student, professor, university administrator, or if you know anyone in one of those roles, we would love to connect. Feel free to reach out and we can host a conversation like this on your campus from any one of our incredible speakers. So thank you all once again. Thank you, Josh and Debbie, and hope everyone has a great rest of the day.
Thanks for having me.
Nice to see you. Bye.